ma'am, respected HODs of all the departments of SVCE, and my dear participants. A very good morning to one and all. I cordially welcome you all to the one-day webinar on Introduction to Designs, Procedure for Protection and Registration, jointly organized by DPIIT Chair on IPR, NLSIU Bangalore, CIPAM and IIC Cell, Sri Venkateshwara College of Engineering, Bengaluru. Jan 10th to 16th, 2022 is being celebrated as Azadi Ka Amrit Mahotsav. The Department for Promotion of Industry and Internal Trade DPIIT is organizing the first ever Startup India Innovation Week from 10th to 16th of January 2022. This virtual week-long innovation celebrations aims to commemorate the 75th year of India's independence, Azadi Ka Amrit Mahotsav, and is designed to showcase all the spread and depth of entrepreneurship across India. In regard of this, I cordially welcome our today's chief guest and resource person, Professor Dr. T. Ramakrishna Sir, Chair Professor, DPIIT Chair on IPR, NLSLV, Bangalore, to the session. We welcome you, sir, to the session. Thank you, sir. I now cordially welcome our today's guest of honor and the resource person for today's session, Mr. Gnanateja Bandi, Patent Agent, Research Assistant, DPIIT Chair on IPR NLSIU, Bangalore, for today's session. Sir, we all cordially welcome you, sir, to the session. Thank you, sir. I now request Dr. Nirmala S. Gupta, HOD Artificial Intelligence, to please read out the brief CV of our today's resource person, Dr. Ramakrishna Sir, and introduce our sir to the participants. Ma'am, over to you.
Thank you, Divya ma'am. It's a great privilege and honor to briefly read out the profile of our today's keynote speech by Professor Dr. T. Ramakrishna Sir, who is the Chair Professor at DPIIT Chair on IPR at NLSIU, and Sir is the Coordinator of the Center of Intellectual Property Rights, Research and Advocacy, CIPRA, at the NLSIU. Sir is a member of different expert committees constituted by Indian Intellectual Property Office, National Biodiversity Authority, Protection of Plant Varieties and Farmers Right Authority, Copyright Office, and member of Institutional Ethics Committee. Sir was the chairman of Postgraduate Council, special invitee of the Executive Council, and also the member of General Council of the NLSIU. Sir's areas of specialization includes IP, intellectual property, rights, law, international law, criminal law, and law of evidence. And Sir has visited the University of Sussex, UK in the year 2004, September, October, under DFID project, the WTO and WIPO in Geneva, Switzerland during the year 2005, June, July, and Sir has also participated in the colloquium on IPR. He was also been visited US in year 2006 at the invitation of the US Department of Justice for studying the IPR enforcement models in US, participated in the Indo-German colloquium on IP at Freiburg, Germany, May 2008, and at the Conference of Parties of CBD at Bonn, Germany, participated in the IPR workshop organized by the Ministry of Economy, Trade and Industry at Tokyo. Then Sir has been participated as the part of Indian delegation in the meeting of the Standing Committee on Copyrights and Related Rights at Geneva 2010, and participated in international workshop on the standards, intellectual property, and the competition law in Phoenix, Arizona State, United States of America. So this is a very brief profile I could give it about today's keynote speaker, Dr. T. Ramakrishnan Sir. We are really heartily welcome you for this event, sir. Thank you. Over to you, Divya.
Thank you so much, ma'am, for introducing such a great personality to our session, and we are really happy to welcome you, sir, again to the session. So I now request Professor Ranjit V to introduce our resource person, Mr. Gnana Tejas, sir, to the session.
Madam, what name he has been registered here, Ranjit?
That's what, sir. Ranjit, sir. Oh, it is in Sushma ma'am's login, sir. I'm unmuting, sir.
Okay.
Okay, sir. Ranjit, sir. Now you can
yes.
unmute. Please,
Yes,
sir.
ma'am. Yes, ma'am. Done, ma'am.
Please, sir.
Yeah. It's indeed a great privilege for me to, introduce our keynote speaker here. Thank you so much, ma'am. So, Mr. Gnanatej Bandi, Research Associate at DPIIT, Chair on IPR, CIPRA, NLSIU. Finished his Masters in Pharma from JNTU and finished his LLB from IIT Kharagpur on IP honors. So, sir is a qualified patent agent in PA 3704. Sir is having experience in handling patent prosecutions, TM filings, and has extensive experience in protection and promotion of geographical indications. Sir's area of research include patents, geographical indications. Sir regularly contributes to iprlawindia.org. He actively took part and contributed in many IPR awareness initiatives. Sir is a recognized facilitator for startups for patents and designs under Office of the Controller General of Patents, Designs and Trademark, CGPDTM. So this is a brief profile view of our keynote speaker, Mr. Gnanatej Bandi, sir. We welcome you as a guest speaker here, sir. And thank you very much for having you over here. And over to you, Divya, ma'am.
Thank you, sir, for reading out and introducing our the resource person to our session, sir. Really, we are happy, Gnanateja, sir, you are with us today. So, moving forward, I request our beloved principal, Dr. Nageshwari Gupta, sir, to give presidential remarks. Over to you, sir.
Respected Chief Guest of the Day, Dr. T. Ramakrishnan, sir. Respected Guest of Honor, Mr. Gnanateja, sir. My dear faculty members and students, friends, very good morning to all. So this is one particular unique event which we are conducting. See, this week is felt as the Innovation Week, and yesterday at MHRD level, they have started e-symposium where we were part of it, and parallelly, we were being part of Universal Human Values, which was organized by VTU on this particular week. And we have a number of events which are lined up in this particular week to create awareness among the people. There is the children, there is the future, the rulers of this particular India. And from SPC side, what are all from Sri Venkateswara College of Engineering, Bengaluru, what are the initiatives that we have taken and how we are progressing? We are going to give you a small information for the chief guest and the guest of honor. So in the year 2017, because we have established in 2001, but in the year of 2017-18, late 17-18, we have started the process of design thinking in our system. So the first year students, they will be learning design thinking process. And it will be all the design thinking process. There is the students who are involved, they will be participating in an idea blast event to share their ideas across the problems that are available in the domestic lane. Okay, for example, some people, they were trying to solve the international problems, but we were focusing on the domestic problem solving. And the second year, we will be asking them to show the proof of concept for the ideas. In the third year, we will be supporting them to transform them into a startup. Later in the fourth year, with the investors and other people, they will be asking them to transform them into enterprise. For that, we have made a separate setup. And I think Mr. Nyanateja sir also was helping us in filing the patents and publishing and all those patents till that particular extent. Now, one particular patent, even it has reached the completed the examination stage. Other patents which are lined up in due course. I think 28th also we are going for one more patent, which is related to the area of interest, which is closely associated with Ramakrishnan sir. It is in the aquaphonics line that we have it, the pattern. And apart from that, our faculty members in this pandemic, see, our college students, a few people, they are self-learners. For other people, we need to do the hand-holding. So that is the kind of students that we will be getting, most of them from the rural areas, but they have a number of problems. What is the challenge that we are facing in these 2 years? That because of the hand-holding session is not available, because we are working from remote, many of the children, they are not blessed with the resources like internet and other things. So some of those things which is getting some delay in submission of the patent, in submission of the documents and all those things. So we are working out the other models, how we can improve that particular. I think we are also innovating some new techniques to improve that particular process also. And we will support with all the agencies who are sponsoring this particular event. And here there is we will be having synchronously, we will be working with that particular agency in improving innovation, realizing the vision of our Prime Minister Narendra Modi and all the other stakeholders who are available. Thank you. And I again welcome our chief guest and guest of honor for this particular event, sir. Thank you, sir. Over to Divya.
Thank you so much, sir. I now request our today's chief guest for a keynote speech. So I request Professor Dr. T. Ramakrishnan sir to start the session. So over to you, sir.
Thank you very much. The principal of SPC College, Dr. Nageshwar Gupta sir, Nirmala madam, heads of the department of and my dear participants. It has always been a delight and a pleasure to be part of the programs organized by Venkateshwara College of Engineering. And I have really enjoyed interacting with the faculty and the students over a period of time. I'm happy that our DPIIT chair, through Gnanateja, has been associated with the patent filing and the patent prosecution. So at the end of the day, that is an important activity of the DPIIT chair. And at the end of the day, we also want to see that most of the innovations that happen at the college level would reach the logical end of getting the intellectual property protection. That's the main objective. And Venkateshwara College of Engineering has been moving in that particular direction. We are really, really glad to know that. And it's also a matter of pleasure and pride to know that SVCE is the only college which has an IPFC, Intellectual Property Facilitation Center, from the MSME. I remember to have participated in the meeting, the first meeting and the second meeting of this IPFC, which took off from SVCE College. I also keep getting report that it has been functioning very, very well. So today, as part of this Innovation Week program of CPAM, we thought we should get ourselves involved in at least sensitizing, plus hand-holding, plus giving a specific direction in the field of intellectual property rights. Then Mr. Gnanateja, after having had interaction with the faculty members and IPFC, he said, sir, since we have covered the patent-related aspects completely, I think this is a time that we should focus on the design protection. That is how this particular program came to be organized. From the whole gamut of intellectual property rights regime, if you narrow down to the design part of it, it is the one which would give a boost to the marketing of specific products. The aesthetically appealing shape that is put in an article, which would attract more and more customers, would also need a set of protection. Let me at the very outset make it very clear to the participants of faculty and students of the engineering college that the context in which you use design is a much, much broader context in which you're going to use the design. The context of your design would encompass various intellectual property rights. The context of your design, where you find solution to a technical problem, would be the subject matter of the patent law. Whereas when a product has been manufactured and sold in the market, this product would get certain shape, certain configuration, certain pattern, ornamentation, or shape in the form of colors, etc. And that particular shape, etc., is applied to the article that you are manufacturing. That shape that you have applied is something which is novel or which is original in nature. That which is novel or original in nature is the one which would be entitled for the design protection. However, as Gnanateja is going to explain as he progresses, this particular shape that you are applying here should not be functional in nature. The moment it becomes functional in nature, it would lose the design protection. There are issues around this as to which particular shape, which particular configuration can be registered and what's the procedure for registration of these designs. All these aspects, I'm sure, would be taken through by Gnanateja himself. But what is important to be communicated at this stage to the audience is that there are quite a few startups that will come up. Quite a few of you are going to spin off into a new organization or a setup and start utilizing your patented product and start manufacturing and selling those patented products. Or you may even trade in certain other products or other goods to which you have attached the trademark. We have been telling time and again that a comprehensive intellectual property protection in the business is the viable way of competing in the market effectively, number one, is the viable way of reaching out to the consumers, the end consumers, who would not be misled by the spurious products that come into the market, who would not be misled by the counterfeited product that comes into the market. So to protect the consumers on the one hand and to protect the interests of the organization, it's better that you have a comprehensive approach of integrating all IPs into the business that you're going to take up. We have always said that in a business, there must be what is called as a visionary approach to the intellectual property rights regime. What exactly I mean by a visionary approach to the intellectual property regime? Where the business policy of the organization is integrated with the IP policy of that particular organization. When I say IP policy, whether it is an institution or an organization or a business, they should have for themselves an intellectual property policy where they would decide as to what is the area in which they should proceed and what are the potential IPs that they have with them, which can be converted into an effective marketable IP. At the same time, when they're working on it, they should also ensure that the IPs that are there already protected by others is not in the process of your activity that violate it and infringe, which calls for a legal action at the end of the day. So both of them should be avoided, and therefore you should have a clear-cut intellectual property policy, whether it's an institution or organization or even a startup for that matter. That is going to give the organization a boost in their activities. So from that perspective, if you look at, along with the law of patents, patent where you have protection for your invention, the trademark whereby you are protecting your mark relating to the goods or the services which you are promoting, the copyright regime, which is equally effective in the business activities as well as academic activities, where you protect all those different kinds of works that are to be there. Designs would become part of that. So from that context, I'm happy that you have a session on designs today. At the global level, this becomes equally important. We see most of the countries adopt the design law, and some of the countries even go to the extent of saying that an unregistered design will also be able to get protection. One such country is UK. However, in our country, it is essential that you go in for a registration of the design, because an unregistered design would not be getting the same kind of protection that a registered design gets protection in the UK. To which I am sure Nana Teja is going to draw your attention to our section 15(2) of the Copyright Act, where it is protected for a certain duration and not beyond that particular duration. But you're going to be referring to that. And therefore, registration becomes relevant. But you should not be worrying too much that you have gone through the process of patent filing, and perhaps the same similar difficulty would be there in filing of the designs also. You should not have that fear at all. Perhaps the simplest process for obtaining registration of any IPR next to copyright is the designs, because you will not have any opposition in the process. And the only thing that you'll have to establish there is that it is original in its application. That originality element becomes so much important, which again, you would be explaining as what is that originality that comes in. Well, friends, I think this is the key that I thought I should lead you to. Kindly make note of all the parameters that are necessary for registration of a design. Make note of the procedure that is to be followed for registration of a design, and also find out as to where you will not be able to register. Although you're curious, you are enthusiastic to register because you come from the technology background, the functional features also get reflected. Functional features are outside the realm of design. That is what you should be keeping in mind. I think with these few words, let me give you more time to listen to the entire procedure for grant of the design protection. Mine was only an initial talk. I thought I should just initiate the whole process. I wish this program all the success. I am sure participants are going to be benefited by that. and assuring that the DPIIT chair on IPR of the National Law School of India University, in particular, me, Nanateja, and Josna, and the CPAM are going to be with the College of Sri Venkateswara College of Engineering in all its activity relating to intellectual property rights. Thank you very much. All the best.
So much, sir. So for briefing on IPR and also giving us insights on IPR and even patenting, sir. Thank you so much for this. And I request now Dhanateja, sir, for giving a session on designs by designs. Okay, so I welcome you, sir, to the session, and over to you, sir.
Yeah, thank you, ma'am. Hope I'm audible.
Yes, sir, you are audible, sir.
Yeah, give me a minute. Yeah, give me a minute, ma'am. I will just share my slides and just.
Sure, sir.
Kindly please confirm me once you see the slides.
Sir, we will be able to see the site, sir.
Thank you so much, sir. Yes. Yeah, a very good morning to everyone. And firstly, I would like to thank our principal, sir, of SVCE College, Sri Nageshwar Gupta, sir, and also to all the team and HODs of SVCE College for organizing and inviting us for this wonderful session on protecting designs. So in this whole session, we will be looking into what exactly the designs are and how these designs are a little bit different from patents. As our in the keynote speech, our professor Dr. K. Ramakrishna sir said that there is like a thin layer between patents and also as well as designs. And what are the technicalities involved in the designs, whether they will get protected under designs or not. So there are few issues with that. So like what are the things that can be protected under designs and also what cannot be protected under designs and where you can go for protection of patentings with related to the designs as well, and also like how long you can protect without registration of designs here, okay, under the copyright law, as the professor said, under section 15.2 as well. So these are the things that we will be keep on looking, and mainly I'm not going depth into the law or exact sections, but I will be keep on teaching on how and also how unique is designs, design protection, and how can you protect these designs and how long these designs can be protected and how can we tap that inventions under our academic projects to come up and protect as in designs here. So normally, like whenever I get a time to interact mostly with the academic people, not only with SVCE College, and there are few other academic people whosoever I could contact them with related to protecting of their intellectual property rights. So mainly they come or else they think like IPR as a synonym for patents. So whatever IP they generate, they say that, okay, can we go for a patenting system? That's it. So they're not much aware about, or else they couldn't able to differentiate about whether that invention or innovations is capable of going under design protections or copyright protections, or even few inventors used to mention that, okay, they would like to protect their trademark or as a brand name as in patent. So there are very differences among these thresholds of our intellectual skills, mainly as a part of our intellectual skills. So if there is invention which is more into the technicalities that is talking, so it can be capable of getting patent system, or else whether it is talking about a shape or else how it look, so this can be comes under a design. So based on that threshold, the intellectual property rights are differentiated into different categories actually. So like as you all know, mainly like as SVC College is already into the patent filing system, actively they are keep on filing patent filings, and also as Nageshwar Gupta sir said that already one patent already had gone through this hearing stage, and it is almost like to get granted maybe within a week or within 2 weeks. So this we are very much into the patent system actually, even with SVCE College when we keep on talking about inventions or innovations. So this is the other intellectual property right where many of the inventors think that designs as in design patents again. So this is the term that they do use always, like okay, design patents. Let's go for registration of design patents. But there is no such term as a design patents under Indian jurisdiction at least. So it is known as an industrial design. So these industrial designs can be protected under our current IPR system. So there is an act called the Designs Act 2000. So under that, these designs are protected actually. So now what exactly the designs and how can we protect that designs here? That's what we are going to look. Now, if you can see this slide here, so nowadays, like from the last 2 3 years, there are more number of this invention or this sort of designs have been keep on filing actually. So which are related with face mask or as the face shields. So when you look into this all 8 face masks here, no one face mask is identical to other. But when you look into the article or else the item, this the item or the article is hold as a face mask. But thing is that when you look into the design, this design is completely different from each and everything. So this is where we are talking about, and this is what we are going to protect. So each and every design that is mentioned here is protected under the designs, and it has been registered as a design under the Designs Act, and it is published. So these are the things that we need to keep in mind, that design all it doesn't talk, or else it is not talking about protection of that particular article. So it is not talking about the protection of mask here. So it is only talking about the protection of that particular design or is the way how it is looking to our eye. So this is how we need to look actually. So how this particular design is looking and how this design or as the article is implemented in that particular design is what is protected under Designs Act. So this in this 1 year when I keep on searching about the design journals here, so there are like more number of intellectual properties not only with related to designs, I'm talking about patent as well, which are related with COVID and COVID related drugs etc has been filed as a patents. And also when it comes to the masks or as the face shields, so these things are filed as in designs actually. So there are like you can see a tremendous growth in this filing of designs. And now a person or else a company or any entity who protects or else files and register this particular design is having all rights on that particular design, and no one can copy that design or else no one can assign that design to anyone until and unless with the approval of this owner of that particular design or else the institute or else the organization that is holding that particular intellectual property rights. So until and unless if I am having any protection on this design here, so I can assign to anyone for commercial purpose. So maybe for a particular time period or else maybe like a completely I can transfer this intellectual property right for a long term period, or else I can have an association with manufacturing capacities or capabilities. Now for example, if you look into many of the startups, what they do is like they are coming up with unique designs and then they are assigning or licensing this design to the manufacturers. So in regard to this, they are even receiving the royalty as well. So this is how we need to commercialize our intellectual property with related to designs here. So now when you look into this slide, it is very clear that we are keep on talking about only the visual impressions or else the visual appearance of that particular article or an item. That's it, right? So always we need to keep in mind that designs is always talks about the visual impressions or else how that particular article looks. This is what protected under designs. In contrary, if you look into the patents, the patent system always talk about the inventions. So the inventions which are having a technicalities, so the inventions which can be product or else which can be processed and how they can be manufactured that particular end product till that end product. Okay, these are the claims that have been protected under patent system. But when it comes to the designs protection, it always talks about the visual impressions or else the attraction of the visual attractions. Okay, how that particular article look. So why this is more important here? So normally even in the previous slide when you look here, when if someone would like to choose any particular mask from this all the masks that are available, we always tended to go with obviously the way how it look, right? The first visual impression we look, and obviously it is followed by the quality of that particular article or else the cloth or material that is used. But obviously the first pickup line is that the how the visual appearance. This is how we always tend to pick these items. So this visual appearance or else the visual attractions is always plays a major marketing tool for an item on an articles. And also like as I said that there is always a trend when you look, the consumers always tend to approach articles which is having visual attracting elements like shape, pattern, or else compositions of lines, etc. So these shape, pattern, composition of lines, etc. These have been defined as a design actually under the Designs Act 2000, which protects the designs in India actually. So normally, like why we keep on talking about the designs protections or fighting of designs and the monetization of commercialization of designs. So always same like an other intellectual property or the patents or else the copyright, etc. So there is always there is a requirement of creative labor or else innovative skills. So they are needed to create such designs and also to apply the designs in any article. Now let's look into like automobile sector. So when you look into automobile sector, like a two-wheeler sector like TVS Motors, or else four-wheeler sectors like Tata Motors, Mahindra, etc. So when you go into that particular departments, along with the IP protections, they always concentrate more on design protections, and there is always they're having a separate design clinics. So they come up with always unique designs, so the designs of their headlights and designs of the steerings as well, the designs of speedometers, so the designs of wheels, etc. So these all are different set categories of designs, and they will be keep on working on such design protections here. And that design labs always spends a lot of their what you call that resources in creating of designs actually. So along parallelly of protecting of intellectual property along patents and designs, the creation of designs is also one of the important tool, mostly like when you look into the automobile sectors and also the fashion technologies as well. So this is that is the reason why always like each design of one particular competitor to other competitor always varies, or else one article of from the one competitor to the other article of one more competitor will always varies. And this is how like they always concentrate more on visual attractions and also to get back more to generate more income by creating a different or unique designs into the market. So then the such designs are always tend to be protected. So if you are creating a such a unique design and someone is creating that unique design of a two-wheeler headlight, okay, and then now if you're not going for protection, and then if you start publishing that particular a unique design in any blog, or else now new trend is that okay, you can just stream on YouTube. So you can show that okay, so and so inventor or so and so person from such and such university, so from SVC college, a student, a third year student of mechanical engineering. So he came up with a unique design of headlamp, and this is how this looks, and this is how he designed. And now if he streamed that in YouTube, it's already a disclosure to the public, and it is not having now novelty concept, because now anyone can copy the design and then they can start making the design here. So this is the reason why the protection of designs are very much important. The protection of designs are very important. Why? Because like to give security to that creative skills of that person who is creating the designs, and also this helps you to generate more income, or else to create income or come up with your own startups with related to designs when we are talking about design protections. And you can even assign your design to like in the same example that what we are discussing here. So you can assign this particular headlamp to let's take any automobile sector, like a two-wheeler automobile sectors like TVS Motors, or else like a Tata Motors, etc. So this is how is a need for protecting of the designs. And also there is a process for protecting of designs in India, and there are various requirement for protecting of designs, and not all the designs can be protected actually. So first we need to look what are the designs that can be protected, and what are the elements of that particular design protections, etc. are also very much needed. Now in India, the designs are protected under one act called as the Designs Act 2000. So same way for the patents, there is a patent act. They will keep explaining about okay, what is defined as in design. So what are the process for design protections, and how long design can be protected, and what are the rights that the applicant or as the owner of the design is having, and what if someone is infringing that design. So these all are explained under the these particular acts in India. So the Design Acts deals with all these things, okay, what design means and how long design can be protected, what exactly can be protected. Now whether this the designed article is protected, or else the design in that particular article is protected, is also important and confusing thing for few people. So these all the things has been explained in that. So this is as I already mentioned that in India the designs are protected under the Design Act 2000. And also there is a design rules as well. So where it explains about what is the filing fee, and also what are the forms that are required for filing a designs, and what is the form that is required to inform to the examiner or the controller that if any design is assigned to someone else. And also there is one more form like to extend the term of protection for these designs, etc. So these all things are mentioned under the Designs Act. See, as I said, there is a Design Act. So under Design Act, have been clearly explained about that. What do you mean by a design? So it only talks about the features of shape. So how that particular article looks, or is the configuration of that, or is the pattern, ornament, or composition of lines, or composition of colors. And the most important thing is that this all should be applied to an article. Why it emphasizes on apply to an article is that when you talk about the feature, configuration, pattern, ornament, or composition of lines or colors, so when you draw in any let's take any white page or a paper, and then if you're drawing this lines or a color combinations or the design of anything, so this will be can be applicable as a copyrightable subject matter only, until and unless this is applied on any article. So this cannot be termed as a design protection, right? So this is where actually the Professor Ramakrishna sir said that the unregistered designs also can be there under section 15 of Copyright Act. So where section 15 2 of Copyright Act talks about even you can protect this design by applying on an article as well under the Copyright Act. So what advantage is there with the Copyright Act is that the term of protection is long in the Copyright Act actually. So sorry, life of author plus 60 years. So this life of author plus 60 years, this copyright is protected. Now if someone is saying that as we are only going with the feature of shape, configuration, etc., and this is a copyrightable subject matter only, and then I want to keep it as a copyright without any registration. So yes, obviously there is an provision for keeping that one, but under Copyright Act what it says is like until the count for 50 articles is marketed, it is protected under copyright. So once it crosses the 50, it is open to the public and anyone can start manufacturing, and it will lose the copyrightability on that article. So to keep safe, as we are always concentrating on the shape or visuality of any articles or else any items uh, uh, or else any features of any particular item. So obviously the marketing is the one most important thing that we always look, and we are not only confined to the 50 articles that is marketing. So we always target more number of articles should be marketed. So we always target that more number of income should be generated. So in that case, always we should go for protecting under designs only. So why? Because it always crosses the 40 count. The manufacturing of 50 items will be crossed, and then once it crosses, it is open to the public and anyone can start copying that. So to protect that, it is the best thing that always go for applying as in design under the Design Act. So then you need not to worry even it crosses the number of 50 items or else it crosses 1000 or 10,000 as well. So we are having a limited time period for protecting, but we are having for more number of articles can be protected under this Design Act. This is very important when we are looking under the designs. Next one is that this article it should be always applicable on the particular articles, and then it should be always judged or else it should be visually it should be visually viewed by an eye actually, right? So it always should be judged by an human eye. So the things that what we see, so when you see any particular mobile or else any chair, etc., so this is always like okay, the way it is designed, the way it is configured, the way it is patterned, the way it is the composition of lines or etc. are there. So this is what attracts to your eye is always protected under designs. It is always having capability to protect under designs. So whether it is protected or not, we need to look actually. So, and there are few criterias as in the keynote speech we already looked into. So there are very few important criteria for designs. Same, there are many important criteria for patents as well. So here, same like a patent, it should be new or else it should be original, and it should not disclose anywhere else before filing. So once it is disclosed somewhere else, it is all obviously it is not a new, it doesn't come under the new, right? And also it should be distinguishable from one known design to the combination of other known designs as well. Now here, the most important thing with comparing to the patents that we always need to keep in mind is that the new or the originality level of or else the examination of that originality level is little bit lesser when compared to the originality with patent system. In the patent system there is a strict sort of originality that okay, it should not exist elsewhere in the world, okay, yes, and it should not be available to anywhere either in the written format or non-written format to the public. before the time of filing of a patent application, right? But here the thing is that the design or else the pattern may be known to someone else, but the pattern that is applying to any article is completely new. For example, there is a pattern of leaf, so which is applied on a mobile, okay? So that particular design of that mobile pattern leaf mobile can be protected as a design there. And now when you're coming up with a leaf patterned chair, so this leaf, the leaf is same, okay? So the design of the leaf is same both in the mobile as well as in the chair as well. But thing is that the article is completely different. So the design or else that particular leaf copyright of that particular leaf is implemented on mobile is completely different. So that article is protected under designs. Sorry, that design is protected under design system, and this design which is applied on article on chair is also protected under design system. So this is how the originality or the newness is looked here. So, and it should not disclose anywhere else as it comes as in prior art as well again. So these are the main important criteria when we look when we are going for the design applications. So like patent applications. So when we are coming up mainly with the product patents, there are few patents that we filed even with the SUCE college where there is an a cooker, right? A cooker which can be automatically off actually, and also there are like absorbable bricks as well. So these are like few unique inventions that SVCE college came up and then they started filing as a patent systems. Now there is again one more option for them, or else the one more interesting thing here that we need to see is that the design of that brick, the design of that cooker, it also can be protected as an design under the design protections. So when we talk about any product, almost all the academia people will keep on concentrating on patenting system only. So no way somewhere they are not more focusing on the design part. Now you are coming up with a unique brick where it can absorb water or else which can be used as an a decorative purpose where it doesn't leave any traces of water etc when the water is flowing through that brick. Now this is a very good technology and this technology will be protected. Now when you are not talking about not protecting that shape, now this shape is already disclosed somewhere else, and then someone can come up with that invention of that design of that brick, even though it is not technically sound like that, but they come up with the normal bricks which look alike of the designs. Now when these absorbable bricks become a blockbuster in the market, and then when you're looking the same design bricks are available somewhere else, people always tended to go for the cheaper bricks where okay the shape of the brick is almost looking same. They may not consider about the technicalities here, so they will go and filing for the sorry go for purchasing of the designed bricks as well. So this is how like you need to stop even leaking of the design also to the market. This is very important when we are concentrating on product patents mainly. So when you are filing a patent on any particular product, there you need to keep discussing with the inventors and also the patent attorneys and design attorneys as well, that how or what are the possibilities to protect that product under the design systems, and how many number of designs can be protected under this. So when you're looking into the cooker, a unique cooker, when you're coming and filing a patent here under the patent system, so there are different components which can be visible. The visual of that cooker, so this can be a unique design again. The cap of that cooker, so this may be a unique design. The holder of that cooker, okay, so that can be a unique. The base of the cooker, so this can be a unique design. So these there are like 4 to 5 designs that can be available in that one patented product, where we are not concentrated more on protecting under the patent system design system here. So this is the reason why we took this particular topic here to discuss with all the HODs and also the students here, young inventors and innovators, to keep focusing on designs as well, not only focusing on the patent. Obviously the patent is always talking about the technicalities, and coming into the designs or the features, this is always best to go for design protections. And as Professor T Ramakrishna sir said that you need not to invest more number of or else high number of innovative skills here, like or else the technicalities no need to be more for protecting of designs. So this is the one of the easiest form to protect your unique designs here. And even like the time for protecting of design is also very less when compared to the patent system. And also the prosecution is also become very easy when you are comparing with the patent system. So this all we can look in the coming slides as well. So here, as already I mentioned about the new or the novelty under the design. So the designs as I said that, okay, so this is not about talking about the strict novel things. So the designs can be improvement to the existing products as well, so the existing designs as well. So for example, if you look into the mask again, so there are different masks here, and there are few improvements to that mask, right? So which is the face mask or else the mask which covers the nose, and there are having an extra design which is protecting the eye part. So where this also can be eligible as protecting under the designs as well here. Or else there can be any completely new concept of designs where you are coming up with complete face shield, so which is looking completely different, as I said, that a leaf like structure which the face shield is looking. And this particular design also can be capable of getting design protections until and unless if someone filed on the design, etc. Okay, so this is what the new novelty talks under the design system. But when you, in contrary, when you're going with the patent system, so it should be completely new in nature, and the elements that what you're using here, and also the components what you're using, the steps or the process steps what you are following to come up with any product in the process patent system. So in the each and every step or each and every claim should be completely new, and it should not exist elsewhere. So you should talk about completely new product. That's what it is coming up, and you need to explain about the role of each and every element or else the each and every raw material, how it is contributing to that. But when you're talking about the design, here you are not talking about each and every element that is contributing to the design, but you are only talking about the feature, how it is looking. So the how for a human eye it looks is the matter, and how it looks for a human eye is what protected. So it is not talking about, okay, what is contributing to the design is, it is not talking about that. But in the patent system, what is contributing and what are the elements that contributes to that patent system or of a patented product or else a process is also very important. And this is what we need to explain in the complete specification of any patent system. But here you need not to explain when you are filing a design system here, okay, how you are coming up with the design and what are the materials that you are using to come up with a design, or else, okay, at what stage you are heating this plastic or else the raw materials, etc., and what is the temperature criteria, etc. So these are all we are not bothering about when we are going to file any design system. The one and only thing that we concentrate in design system is that how that particular design looks, that's it, to an eye. So if it is a new or a novel in nature, when you're looking or comparing with the other products or other articles or the same articles having in the market, if it is completely new, yes, it is eligible to get protected under design systems. So this is what the concept of novelty when you compare with patent systems. So now here one more example that I would like to show here. These are all are also the protected designs here. So where down row you can see the four-wheeler vehicles. So each and every vehicle is having complete different design structures. So the how they look, okay. So that designs, and also the here the four chairs here. So each and every chair is having different pattern or else the color combinations and the designs or the look how it is visual to eye. Now, when you show these four chairs to any of the participants, they can easily recognize or differentiate each and every chair with other. So nowhere each and every chair is completely like similar here. So they may have the four legs here. In the same way, the fourth chair also may have four legs, but the design is completely different. So this is what it talks. So this is what we need to understand, the thin layer between how it looks and also the article. Now here, when you look into these designs, nowhere it is saying that the chair is protected under this. So it always talks about the design of the chair is protected. So anyone can manufacture chair, but no one can manufacture such a designed chair, or else no one cannot sell such a designed chair or design protected chair until and unless the owner of that design gives the assignment or else any a written consent that, okay, so and so you can a contract that, okay, it can be manufactured, or if you license it to someone else for some royalty. So until such conditions, no one can copy that design. So I can come up with manufacturing of chairs, but I cannot manufacture that designed chair here in the market. That's same way with four wheelers as well, and the same way with footwear as well. So there are different designs of the footwear are protected actually. If you look, if you look into the design journal here, and there are like many a common goods like for example utilities like mixies and also the gas stoves, and as I said that cookers, etc. There are many different sort of designs that are protected under design system. And as I already mentioned that the face masks and face shields are keep on increasing actually in the number of filings, and each and every time there are always a unique feature or else the unique design is keep on of filing under the design systems actually with related to this face mask or face shields. Now if you do the landscape of that particular designed face mask only, you can just look into like thousands of designed face masks have been already granted design protections under the Design Act, and maybe in the last 2 years there are hundreds of these face masks have been filed and granted as well. So this is what we need to keep thinking about the designing part. So when in the academia, so when we come up with our inventions or the design thinking, so we always think that okay, there is a chair, or it's already a design chair, so we may not protect, or else may not come under the unique design. But there are always possibilities that under your strength of your technicality strength, you can come up with one more unique feature or else one more unique design of the chair. Now, for example, if you look here in the 4 chairs, there is the backrest is always looking like a straight or a little curved. Now, if someone is coming with a full curved backrest designed chair, where which is having like a more uniqueness in that particular design, obviously it can be protected under design. So before that, obviously we need to look whether such designs are protected, are already filed or not. But when you're comparing these 4 chairs, obviously here the chair is not there. So it can be capable of getting design protection as well. So this is how we need to keep thinking and also keep polishing about the design protections. So the design protection always the most important thing that we need to keep in mind in design protection is that design versus article here. So chair is an article, or as the car, or as an automobile is an article, or mobile is an article, or as a footwear is an article. So these all are the articles. So where the design is applied. So the design is what, as I said, like color combinations or the way how it looks, etc. The patterns, ornamentations, etc. So now you are coming with such a designed pattern, etc. on any paper. So that particular copyrightable subject matter is applied on any shoe, or else it is applied on any mobile, or else applied on any trolley. Okay, if you look into the trolley, there are more number of trolleys as well filed as in design protected trolleys under the designs when you look into the design journal. So these are different categories or sets of articles here we are talking. So each and every article is similar. So there is a trolley. So company A, company B, company C will come up with a different variety of trolley. But thing is that the design of the trolley is completely different when you are comparing. So this is what protected. So Design Act always protects that design which is applied on that article. So it never talks about that article. So article is not protected, the shoe is not protected, but that designed shoe is protected. Okay, so this is what a thin layer that we always need to keep in mind. And also this is where it is also an advantage for inventors that they can come up with more number of unique designs when you are thinking about coming up with like a footwear designs. Okay, when you look into different designs, and you can come up with unique design by comparing and by looking into differently protected designs in the under the Design Act 2000. So these designs always should be differentiated by eye. So whatever it is visible to eye, so when you show some design or else an article to someone and a similar chair to someone else, he should recognize that, okay, this design of the chair is completely different to that of the chair that is filed recently. And as a professor said that the functionality of the article, here it is not talking about the functionality, but it always talks only about the design itself, that's it. So it is not talking about how it is functioning. So it is not talking about the mask. So okay, like how much percentage it is allowing the dust particles. So whether it is 99% safe or if it is 100% safe, this is not talking about that technicality related things, or else it is not talking about the components that are used in manufacturing that design, that face mask. So it is not talking about, okay, how much percentage of so and so material used. So during that manufacturing process, what are the steps that are you followed? So this is not talking. So the functionality part is at all not mentioned, or else it is not protecting only in the that article, but it only concentrates, or else it only confines to excuse me, it only confines to the article how it looked. So when someone is looking, so okay, so this is the design of that face mask, and you can just differentiate this design with other design. That's it. So it is not talking about, okay, how good quality it is, or else, okay, how much percentage of dust particles it is allowing, or else like what are the materials or raw materials that are used to manufacture this article. So these are we are not providing in the claims part, etc. Like as of a patent, because in the patent it is very important that you need to mention each and every component that are used. So how you are manufacturing that, okay, what are the components that are used, and what percentage of components are used, and what is the role of that particular product, and how it is dependent on that independent claims, etc. So this is what you explain in the patent system. But when it is coming into an article or else coming into the design system, it is not at all concentrating on that, but it only concentrates on the designing of that particular article. That's it. Okay, how it looks. So this is what only protected. So when if someone is protecting the face mask and someone is saying that this is design protected, and then if someone some other person who manufactures with the same material, but thing is that the design is completely different, you cannot claim that the designed or the protected design of my face mask, the material is similar to that of the design of XYZ, where he is using the same material. So it is not talking about the material at all. It only talks about the part of the design or how it looks. That's it. So this is very important when you're looking into the design protections under the designs. So now, how long this design is protected? So now we know that what can be the protected under designs and what are the things that comes under designs like novelty, etc., and what exactly is protected under designs. So now the most important thing that we need to look is that how long that design is protected. So when you look into the patent system, the patents are protected for 20 years, as we know that. But when it comes to the protecting of designs here, the copyright of the design is protected initially for 10 years, and then it can be extendable to 5 more years by requesting to the controller to extend that 5 more years of that copyright on that. Right. So here total year of protection is 15 years, and then after 15 years it is open to the public and it cannot be renewable. So the term of protection for designs can be till the 15 years only. So unlike in patents, it is till the 20 years. That's it. Now there is one more concept, as I said. When you are when it talks about the protection of designs here, it always talks about copyright of that particular design. Means that the design, the design, how it looks is something known as an copyright. Okay, how it is applied on that article. So the copyright of the design is protected for 15 years. Now when someone is not going for protecting of that copyright of that article here, as I said that in copyright it is always life of author plus 60 years. It is the term of protection. So now there may be some inventors or innovators, they doesn't want to go for they want a long-term protection, so they doesn't want to go for protecting under design systems. So they always tend to go for the copyrightable system. So here there are disadvantages, as I said, that when you are protecting under or you are not filing under this design, so it can be protected only till the count crosses the 50 number of items into the market. Okay, so once it is crosses, then it loses its copyrightability, and then it is now subject to disclosure to the public, and then anyone can start using that. But if you want to go for a strict protection for the visually visual look of that design, or as any shape or ornamentations, etc., so it always advisable to go for the design protection where you can protect till 15 years, and then in initial 5 years only, if someone is not interested to come up with their own startup, or they are not coming up with the production of that designed material, so they even can license to the players who are good in that manufacturing capabilities. This is how we need to tap the commercialization part, and this is a complete different subject matter actually. So regarding the commercializations and licensings, etc., also we can discuss in the coming sessions. So this is how and also this is how long this the design can be protected. So now what are the differences between the patent system and also design system? This is a very important thing, because when you talk about the designs, when the look of the product, so how this is looking, or else when you come up with an end product which is in the market, so where that product may have many technicality features in that, many functionality features in that, or else that inventions will be a sound in having more technical innovation related things. So this can be for the product as well as for the process as well, right? So both can be protected under patent system. So the term is, as I said, that 20 years, and then 10 years is for the, 10 plus 5 years is for the designs. So in the patents, when you talk, you always concentrate on the technical features, the functionality of that particular product. So how and what are the components that are used to prepare that patented invention. And as many of you have already gone through the phase of filing patents in the most of the departments, by this time it could have been very clear that when you're going for the patent system, it is not that easy to come up with a 2-page write-up, or else go for the patent filings. So you need to come up with a background of inventions and what are the problems that are already existing, and how our invention could able to address that problems, and how our invention is prepared actually in the market, or what are the important components that are used here, and what are the essential components that are used here. So without that such components, we cannot come up with our invention to the market, right? So each and everything should be explained, and each and every concentration or else the portion of that or contribution of that material should be explained in that patented disclosures. But when it comes to the designs, nowhere it is concentrating about the technical features, etc. It only protects the appearance, and it only talks about the disclosure of the claim of that one claim, which talks about, okay, how it looks, okay, what are the color patterns on that patented article, or on what article it is imprinted. Okay, this is what it talks. So this is a very much clear difference from the patenting and also the design systems. Now there can be few designs or as a few inventions which are like sound in the designs as well, and also which is having the functionality concept as well, right? So there may be few designs. So in such cases, what happen is like the functionality concept always, if it could able to come under the patent system, so this is where we protect that functionality under the patent systems, and then the feature or else the visual impact or the visual look is always protected under the design systems. So this is how, when there are like two intellectual properties are associated with any one particular design or else any patent systems, this is how we need to differentiate or concentrate. So nowhere think that when we are only going for a product patent, this can be protected under the patent system. So that the product can be patented, but how the product is looking is not protected under the patent system. So this comes under the design process. This is very, very important thing when we are going for filing any patents under the product systems. So this is what the overlapping of design and the copyright that we discussed here. So where the copyright on that particular design is always ceases once we produce more than 50 times. So once the number of count for the 50 crosses, the copyright of the design always lapses, and then it is open to the public. So now coming into the application fees for the designs. This is application fee. There are the two set categories under the design systems. Not only the design filings, almost all the intellectual properties like patents, copyrights, trademarks as well. So for the natural persons, startups, and small entities, there is one category of fee, and also for all other entities which are not a natural persons or startups, and all other organizations, there is one more set of fee actually. So 1,000 rupees is the filing fee, so which is very low when compared to the patents. So in the patent also it is low only, like for the startups, etc. It is like 1,600 rupees, 1,650 rupees. That's it. But when it comes into the natural persons, it is the 4,000. When in the patent system, it is for all other entities is 8,000 rupees for the online filing of the patents. So this is the difference in the filing of fee. So if anything, for example, now any single inventor from your institute or organization, or else any student is coming up with any particular design, and then he would like to go for filing of designs, the application fee for that natural person is only 1,000 rupees. And then if any institute or organization would like to go for filing of designs, and the inventors will be the same, the person who created that, but the applicant will be as a startup or as a particular company, or as an institution. So in such cases, whatever for the startups it is 1,000 rupees, but for other entities or else other institutions it is 4,000 rupees for filing of that design under design office. So this is the process for designing actually. There are two sets of the filing mechanism. So one, in either online you can file designs, same like patents, and also the offline mode also you can use. So same, this can be applicable to the patents as well as the trademark as well. So by sitting comfortably with your laptop, you can start filing your designs. Any patent agent, registered patent agent can file. The patent agent is also an agent for filing for designs as well. So he is not only the agent to file a patents, but also he's a registered patent agent for design filing as well. So if you have approach any patent agent, then he can start filing this design application through online mode. Or if you're interested to go for the offline mode filings, you can just download the forms, and then you can just fill the forms, and then you can send it to your particular patent office. So there are 4 patent offices in India as per the territorial jurisdictions. So from the southern part, the IP office that always deals with the filing process, etc., is the Chennai patent office, Chennai office, IP office. So where now, if you buy offline, if someone if in offline mode, if someone files to the Chennai, and then all the design applications actually within 1 week or else within 2 weeks max, it will reach to the main head office of designs, which is located in the Kolkata actually. So there it reaches. It reaches to the Kolkata Patent Office, and where the process for examination begins, and then they look into the procedural aspects. Okay, whether this particular invention is having all the disclosures, etc. So this is what are the different stages in filing of in the filing of the trademark design applications. The form 1 with all the details of the applicants is very much important. Sorry, sir, can you please mute? Yes. So form 1 is the form where we need to give all the details regarding the applicant, or else who is the applicant, or who are the inventors involved in that particular design, and also the details of that design, and the complete details and address of that applicant should be furnished in that form 1 along with the prescribed fee. So this can be either submitted through online mode or else the offline mode. So once on the receipt of the applications, so the office, the patent office in the Kolkata, which records the date, and also the serial number will be generated actually. So the serial number will be the same number for your registration number as well. The design number and the serial number will be same. Design is protected under the designs actually. So here in the patent system, so once you apply or once you file a patent, so there is something called as a publication stage. But here the publication won't happen until and unless the examination stage crosses. This is one difference with related to the patent system. So once the serial number is generated and once it is ready for the examination stage, so this will be shared for the examination department to conduct the examination on the particular design. So they look into the novelty aspects, whether such novelty is already there or not, or whether it is completely new or not, and also the details. They look into the details as well. Okay, how long? So what are the things that are protected under that? Or what are the details that they have mentioned? The color patterns, or is the shape, how it looks, etc. Or else on which article they are using that. So this is how they look into different substantial grounds as well with related to the novelty and non-obvious, novelty and newness of this thing. So where based on that the examination report is generated, and once if it is not having any such objections with related to the this such grounds, so this will be published directly, and then it is registered, and also it will be published directly. But when there is an objections, or else the examiner finds that okay, it is not having formality disclosure issues with related to names, etc., or else with related to the substantial grounds like novelty, nature, etc. So they clearly explains each and every ground under the examination report, and then it will be served. So once upon you receive the examination report, so within 3 months of time, we need to reply to that examination report. Once you submit that reply to that examination report, so based on that reply, so either it can be accepted or else the hearing can be scheduled on based on the reply that you have given to the first examination report, and then the matter will be decided accordingly, like based on the hearing status. Okay, how you have defended your arguments based on that objections raised there. So after that, it will be registered or else it may not be registered. But once it is registered, the design will be published under the journal. Under the patents journal. So there is separate clause for the designs as well. So every week on Friday, the journal will be published. So on that journal, if you look, there are like number of designs that are filed, and also the details of the design, and the number and the classification of designs, and the applicant of the design will be disclosed along with the design that what we applied. So this is what the filing process involved, and this is very simple filing process, and unlike the patent system where there will be like you need to wait for publication, and then you need to request for examination, or else you need to go for the expedited, or else the request for early publications or expedited examinations there. But here almost like it goes in the very fast phase. Generally, like when you look into the design filings in the market as well, if someone is filing a design, the designs are registered generally within 3 to 4 months. So if everything is perfectly applied here without any objections that during the examination stage raised, then the design can be registered within 3 to 4 months only. So you can see many people whose designs are registered within 3 to maximum 4 months. So this is how fast the design process or registration works. But for the patent system, it takes at least minimum to 8 months or 9 months if you go for the expedited process, or else if you go for a normal process sort of thing, it even takes till like 2 years as well for getting a patent registered. But here, the designs registration, this is one more advantage to protect your intellectual property under the design system is that it can be like you can receive your design registered certificate, or you can get that intellectual property on that particular design within 3 to 4 months. And also there is an interesting finding by the patent office, the design office, where it says that, okay, most of the objections during the examination stage are based on the formality issues only. Like, for example, almost like 90% of examinations, the reply examination results are based on the formality issues. Like, for example, with related to the size of the design, okay, that as per the rules that you need to submit, upload it, or else the details of the inventor, or is a classification, under which classification you are submitting, or else appropriate office, whether you are filing under that particular appropriate office or not. Okay, these are the formality issues that always mainly observed. But there are few inventions, or sorry, few designs where the substantial grounds are also invoked here with related to novelty concept. In such examination stage, this that registration or else getting of design certificate may be little bit delayed, like 3 to 4 months extra. So maybe it takes 8 months to get a design, and also you need to reply to that examination report in this due process, right? So this is how. So if someone asks that how fast we can get a design protection, we can say that clearly, like within 3 to 4 months we can get a design protection. So coming into the international, there is something called as international design system as well. So to protecting your designs. So as I said, that designs or else intellectual property is always a territorial in nature. So if you want to protect your patent in India, you need to approach Indian Patent Office, and it is only protected in India. So if you want to approach each other jurisdictions, you need to approach each and every country there, and then you need to go for filing of patent there, or else you can go for one more route that is known as a PCT route, patent cooperation treaty, where with one application you can preserve your novelty in other nations as well. So you can just with one application you can enter into other nations wherever you would like to protect your patent system. Same way, there is a Hague system, or Hague classification system is there for international registration of industrial designs. So where there are 74 contracting parties. So under this system, what happens is that with one registration, you can go and with one application, you can go and start filing in protecting your design in under the 74 contracting parties here. So this is how international filing of designs can happen. If you're looking to, if you're willing that, if you're thinking that your design or else your proposed design is having that marketable capabilities in other jurisdictions, obviously it is always advisable not only to go for filing under the Indian jurisdiction, but also you need to approach that particular territories where you feel that your market can be more, or else you can capture that particular market in that segment of product or article where which you are protected your design. So never always confine protecting your designs only to the Indian territory. But if you feel that this design is capable of getting a good market or as recognition in other territories, it is always advisable to pick up that territories, or look into that territories, either US, UK, or China, so or Germany, whatsoever it is. Okay, so you need to go or approach to that territory, and then you can start filing. And if you're looking only to file in one particular territory like US or UK, then it is always advisable to go in a normal filing to that territory, approaching that local attorney, and then you can file. But if you want to go for filing in more than 10 or else some contracting parties which are under the Hague system, it is always advisable to go with one process and one filing fee. With that, you can start protecting under this particular contracting parties as well. This is how international design protection system look while you are protecting your designs. And this is what I would like to convey here is that, okay, look into your institutional inventions, where there are many inventions which are capable of getting industrial design registrations actually, which maybe by this session, I think there are many inventions or many designs that could have been come to your mind that where you have neglected, like going for protecting or else filing as in design protections as well. So my one sincere request is that when you are coming up with your academic projects or else inventions, when you are trying to go for filing of patent systems, so kindly look into that product and capabilities of that product, whether it can be capable to get registered as a design. So once it is, the design is registered, so this helps a lot when coming or else getting your business or else startup to get succeed. Intellectual property assets always add in value for this particular designs. And one more thing I would like to convey here is that it doesn't mean that always you need to have a end product in your hand when you are going to file a design protection as well, like a patent system only. So the mere idea of that particular design and also the article on which you are going to design is enough. So if you are very well established that a particular design can be this particular design can be applied on an article of face mask, so this can be protected, then you need not to wait till the face mask manufacturing happens and then come to your hand to file, or else to have that particular product in your hand while filing a designs. You can just go for filing of designs and then you can start manufacturing. So once the manufacturing unit comes to your hand, even within the 3-4 months, the design also can be granted, and based on the novelty criteria, etc., and then it can come to your hand as well. So this is how we need to concentrate on design filings, and also we need to concentrate on tapping the design inventions during our institutional inventions, etc. I know that when the inventors or as the HODs of other departments can have an interaction with any attorney or else a patent agent or any patent attorney, IP attorney. So by discussing their inventions, they can find many number of like capable design applications as well. So this is how we need to keep generating and increasing the filing of designs. So concentrating on the patent system or as the technicality related inventions is one path that we need to go for protecting our inventions under the patent system. But the way how it looks or is the how it is designed is also very, very important when you are coming up with design protections. And that's all about the design protections. And then now it is open to the questions. And I would like to tell one more thing that as today is the National Youth Day, so Sri Swami Vivekananda's Jayanti, where he said that just pick up one idea and keep working on that one particular idea, and then keep all your energy on that idea to get fulfilled. In the same way, I would like to add that keep that particular one idea in your mind and keep working hard, and then even just go for filing of that intellectual property before getting into that market, that particular property into the market. So that's how like we can keep increasing young innovators and inventions from academic laboratories or else academic project level only. So that's all with related to the designs, and then I'm open for the questions. Kindly do ask me like whatever questions that you're having with related to the designs or else with related to other intellectual properties or the patent systems here. Thank you.
Thank you so much, sir, for that motivating quote. And if anyone wants to interact with sir, if you have any doubts, please open for it. Please, the platform is open. You can ask any questions to sir. Participants, if you have any questions related to patenting, yes, you can ask sir.
Yes, I think someone raised hand.
No, sir. It is from start of the session. It is like that only.
What is the problem? What is the problem?
No, someone raised its hand, sir. They forgot to down their hand. Some participant.
Only Muniraj have raised the hand, madam.
Yes, sir. Only one.
I think I lowered the arms.
Yes, sir. Yes, sir. So, dear participants, if you have any questions need to be discussed, need to know, clear your doubts in patenting, please, you can discuss with sir. The platform is open for all. Okay, well.
Good afternoon, sir.
Yeah.
Good afternoon, sir. My question is, once the Indian patent after prior art search, if our design is fitting into the Indian patenting system, sir, what will be the next procedure, sir? Hello, sir.
I hope I'm audible. Yes, sir.
Sir,
Sorry,
I need
actually,
to
I
just.
muted. Yeah. So you
Yeah,
got
yes,
disconnected here. Can you please repeat your question, please?
Sir, actually, after prior art search, sir,
Okay.
our design,
Mm-hmm.
it is able to apply for Indian patenting system, sir.
Okay.
Then what is the next step that we have to move forward, sir?
Okay, ma'am. So again, I think there is a little confusion we hear when you are talking about the patenting of the design, right? Are you talking
Yes,
about
sir.
the design protection, or else whether you are talking about the patent completely different?
Patenting, sir. Patenting, sir.
Patenting.
Yes, sir.
Individual. Yeah, you are not talking about the design part here, right?
No, 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 sir.
Yeah. So yeah, with relate to the patent. So when you look into the prior art and then you come up with that, okay, such inventions or your invention is completely novel in nature. So the
Okay.
next stage is like, okay, you need to coming up with the drafting of your patent application actually. So you need to
Okay.
start drafting your application background with the important components of that particular specification,
Okay, sir.
what is the background of that invention and how your invention is working on, what are the important components of your invention, and then you need to start drafting of the claims, and then you need to come up with figures if like with related to the product or as the
Okay, sir.
process, if any figures are involved in that, okay, you need to start drafting of that application. And
Okay, sir.
obviously there will be a little bit difficult when drafting the patent application, or like in academia always the technical expertise, all the inventors are technically expertised, but thing is
Okay.
that drafting that application as per the patent rules is a different ball game again.
Okay,
So
sir.
yeah, so for that you need to always sit or discuss with the patent attorneys or the people who already filed the patent applications. There are many individual inventors as well who
Yes,
file
sir.
the
Yes, sir.
patent applications actually. So you can just sit with them, discuss, or else sit with your IPR cell or as the patent agents, and then you can just draft application, and then you can proceed with the filing of application. So the next foremost important thing is that the drafting of patent application. So how strongly you draft the application, and then you need to go for filing of your patent application. So once you start your filing of applications, then the process for publication and then examinations, hearings, etc. will start.
Sir, sir, and here the clarity is required, sir. Indian patenting system, when we are applying, what
Yeah.
comparisons we need to give in our application, sir?
Whether you are applying for Indian patent system or else like whether you are applying a patent in other jurisdictions as well, the first
Okay.
and foremost thing is that the novelty concept. So it should not this particular invention or else the components what you are talking or as the product or process what we are disclosing in the patent application, what you are filing in India, it should not have or else reflect that okay already existed knowledge elsewhere in the world. So we
Okay.
are not only talking about the inventions which are present in India, but there
Okay.
may be a little close or else exactly similar invention in US or UK. So now if you're drafting that application, such components in this application, and then if you're filing, obviously it may not get patent right here. Okay, it may not get granted in under the patent system. So so the comparisons is simpler. You need to look that okay how your invention is different from other all existed inventions. So this
Okay, sir.
uniqueness, it should be compared with other jurisdictions, not only with the confined to Indian system.
Okay,
And
sir. Okay. Okay.
if you can find any prior arts with related to your invention, so there are a set of strategy while we are drafting a patent application. We always refer to the prior arts, a similar prior art, which are a little bit closer prior arts, which under the background of invention, so which is available maybe in the US or UK patent application. And
Okay.
what it is talking about, and then what our invention and what that invention is lacking, and then what our invention is addressing that invention. This is what
Okay.
very important.
Okay, sir. Thank you. Thank you, sir.
Thank you, ma'am. Thank you.
Thank you, ma'am, for asking the question, and thank you, sir, for answering the question. Any other questions or any other queries need to discuss? Okay. Thank you so much, sir, for enlightening us in depth about how to protect unique designs, important criteria for designs, and patents also. And you also explained about designs versus article and what are the terms of protection. So seriously, after your session, we came to know what are the do's and don'ts need to know before applying for a patent. And thank you so much, sir, for creating awareness in our young innovators regarding patenting, sir. Thank you so much, sir, for accepting our request and to be the part of this session, sir. So,
Madam, now. Okay.
Yes, sir. I now request Subramaniam sir, Assistant Manager, CIPAM, for closing remarks.
Yeah, ma'am, I think you need to unmute. There is one account with the name CPAM.
Yes, sir.
Subramaniam, Mr. Subramaniam joined under the CPAM. Yeah, he is. Yes. Yeah.
No, I made it, sir. I made it.
Thank you so much, sir. Thank you.
Sir, can unmute, sir.
Sir, over to you, Subramaniam sir.
I cannot unmute, ma'am.
No. We are able to hear your voice, sir.
Okay, thank you. So a very thank you for the organizers for this program. On behalf of CPAM, I extend my sincere thanks to the NLSAU Bangalore and the college for organizing this wonderful session as part of the Innovation Week. Thank you, Professor Ramakrishna sir and Teja for their thought-provoking session, and their words regarding the design will help the younger generations to come up with more design filing. My sincere thanks to Mr. Karan Thapa sir, Deputy Secretary from DPIIT, and Ms. Pearl Shopti and Ms. Aruna Tiwari, Assistant Vice President from CPAM, and my colleagues who are giving the concrete steps in organizing this webinar. And finally, thank for all the participants. Hope this session will help you to come up with more IT activity in the future. Yeah, thank you one and all for the organizers, resource persons, faculty members, participants. All. Thank you one and all.
Thank you so much, sir. I now request Dr. Nirmala S. Gupta, ma'am, to render the vote of thanks. Ma'am, over to you.
Thank you, Subramaniam sir, for thanking all of us, and we need to thank you also. It's our privilege today, like myself, the convener of IIC Cell SVCE, as well as an employee of SVCE family, so to propose the vote of thanks for this particular occasion of National Innovation Week, which we are celebrating today with hosting one webinar. So I, on behalf of SVCE management, principal sir, Dean ma'am, and Institute Innovation Council of SVCE, and on my own behalf, extend a hearty thanks to the today's chief guest and keynote speaker, Dr. T. Ramakrishna sir. So thank you very much, sir, for your valuable time and a briefing about the introduction about the design and the patent. And it gives me an immense pleasure to thank our today's session speaker, Mr. Gnanateja Bandi sir, for giving us an insight on covering the designs, design acts, design protections, criteria for design, copyrights, trademarks, and a lot more on design versus article, then patents, overlapping of design, copyrights, filing design, and a lot more, which sir has covered by taking the scenarios and case studies with relevant to the pandemic of COVID situation right now. So we also thank you for your wonderful insight and the guidelines and the suggestions, what you gave it to all of us today, sir. We thank Gnanateja, sir. I thank our beloved principal, sir, whose constant support and encouragement will be always with us for encouraging us to conduct such kind of events under the banner of IIC, which is an MHRD initiative. And we are celebrating even all the days which have been listed out as the major events for the whole country. So we thank you for your constant support and encouragement, sir. And we also thank our Dean ma'am, Dean Academics ma'am, Dr. Purnima GR, for her constant suggestions, support in rendering and executing such kind of events in our institution. We also thank all the department HODs and all my faculty friends for your presence and cooperation throughout the webinar. Last but not the least, I would like to take this opportunity to thank our I could say gracing the occasion and closing the ceremony given by Subramaniam sir. A special thanks to you, sir, for joining us at the end of the session and remarking the closing of the event. So we thank you also, sir. And finally, I would like to thank all IIC members, NISP team members for supporting us for conducting this event under the banner of IIC and all my dear participant student friends. So thank you once again for your presence and showing the interest to know about IP, design, guidelines, filing patents and everything on the procedures. So thank you one and all. Over to you, Divya ma'am.
Thank you, ma'am. And I thank all the participants, our resource persons for making this event such a great event and for the success of this event. So thank you all and thank you so much.
Thank you.
The feedback.
Thank you, sir. Thank you all. Thank you all.
Thank you, sir.
Thank you. Thank you.
Sorry, sir, one small announcement. The feedbacks will be shared in the Kaizala group for all the students, participants, and the faculty and the staff participants. Please kindly give your valuable feedback. So we will be sharing the link within few minutes.
So I request all the participants to give your valuable feedback. Okay, thank you. Thank you one and all.